I got four little quick questions for you.
Okay.
My friend is a U.S. citizen, and his wife got B1, B2 visa.
Right.
After that, her I-130 got approved 1 week later. So, can she come to the U.S.?
Where is she right now?
She's in Africa.
Okay. She has a tourist visa, correct?
Yes.
Okay. So this is the story.
Mm-hmm.
You are allowed to come to America to visit. You are not allowed to come to America on a visitor's visa for purposes of getting a green card.
Okay.
There is a possibility that when she comes into the airport, they will say, you have a problem, lady. You've already filed for your green card. How do we know you're just coming to visit and not live permanently? If she testifies in the airport, one of three things could happen. Either they can say you're lying and they could deport her at the airport. It's called a summary inadmissibility. They could let her in and say you're ineligible to adjust your status, or they could not say anything and just let her in. Those are three possibilities. I don't know what would happen. You know, it all depends on each particular individual. Now, if she does come and visit, she has to wait at least 90 days before, if you're thinking in the back of your head, well, what if she comes? Could she get her green card here? Well, A, she can't come for the purpose of getting her green card, but let's assume she comes without the purpose of getting her green card. Let's just assume she comes with the intent of visiting her husband and then stays 90 days and then wakes up one morning and goes, aha, maybe I should get my green card. She can file her adjustment after 90 days, but, you know, you're taking risks by doing all of this. My advice would be, you have an I-130 approved. She's a few months away from getting her green card. Just finish the process up.
Okay, but, you know, the purpose is her husband is in the hospital for now. Reason why she got a visa.
Okay, so then, yes, she should come. Absolutely. If her husband's in the hospital, she should be by her husband's side.
Okay.
Okay?
Okay, so the second question is, how long does it take for somebody who he's on the food stamp to be filed for somebody for A680?
An A what?
64. For A6.
If somebody's on food stamps, the affidavit support's gonna be useless. They got to get off food stamps.
For how long?
At least 2 or 3 months.
Okay.
Yeah.
So the third question is, how about if for this year you filed less than 10,000, but the couple previous is 43,000 and 37,000.
They're going to base it on your income this year, so you're going to need an affidavit.
Oh, this year?
Else. Yes.
Okay, so for the last question is, how long does it take the I-30 for a U.S. citizen?
An I-130 takes about 9 to 12 months right now. It should take 6, but it's taking 9 to 12.
Yeah, what I'm saying is from the USCIS to NVC, from NVC to the EU embassy.
Okay, USCIS to NVC is about 8 weeks. Depending on how fast you work with the National Visa Center, you can finish the whole National Visa Center in a little over 90 days.
Okay.
All right?
Thank you, Brett.
You're very welcome. Thanks for watching, Frank.
When my mom passed away, and I'm trying to get my siblings, my 2 brothers.
Right.
And I hired a lawyer. Somehow, she never really gave me an answer.
Okay, so let me give you an answer, because I know this case already, like the back of my hand, because we've talked about it on 2 other shows. If your mom filed for your brothers and sisters, and the I-130 visa petition was approved, and then subsequently your mom passed away, which is what happened, only because I've talked to your sister for the last 2 shows, I know this. And your brothers and sisters are in the Philippines.
In the Philippines.
Right. You, as the brother or sister, can step into the shoes of your deceased mom. You can write for a humanitarian waiver, not through the National Visa Center, but through the USCIS. You literally write USCIS and request a humanitarian waiver to step into the shoes of your deceased mom. A close family member like yourself can do that. And what is a humanitarian waiver? A humanitarian waiver would be, you know, my brothers and sisters need to come here because of economic reasons, because of family unity, because of maybe medical concern. There's a lot of different humanitarian reasons why they would need to be reunited with you. Any one of those would work. And then once USCIS approves it, then you can complete the case. They go back online to the same spot they were before your mom passed away, and they can get a green card. So I'm not sure what your lawyer did or what your lawyer didn't do.
I don't really know,
but that is
I
the
was,
process, and we could obviously help you if you need help.
And she even told me that my brother, the one that's married, is not qualified. And I said, how come? Because I know someone that did petition their siblings.
So then I don't know. I can't read your lawyer's mind, but we can help you. Hold on one second, okay?
So I'm calling on behalf of a friend of mine. She has been married to her husband for 5.5 years, I believe. So they they filed the I-751. I think that's the petition for
remove the conditions.
I-751. Am I getting that right?
You are getting it right.
So, yeah, so she filed for divorce from her husband because he's been in and out, he's going in and out of prison.
Okay.
And they sent out an RFE for a final divorce. And she's not going to be able to get the final divorce before the date that she has to reply. She wanted to know, she thinks the case is going to be denied. Can she refile a new I-751?
She'll file a new one if it gets denied, and she'll have to file that before she gets put in removal. So respond to the RFE as best as you can. Here we are with the divorce. We're this close. This is the documents, however you want to describe how close you are. And hopefully they will hold the case, and you request them to hold the case open pending the completion of the divorce. Most likely, they will deny you. Hopefully, they keep it open and give you another RFE. But if they deny you, then you want to refile a new I-751 immediately based on a bona fide marriage that terminated in divorce. And even if your divorce isn't done by that time, by the time USCIS looks at your papers and sends you an RFE, which is the request for evidence for the divorce, hopefully your divorce is done at that point.
Oh, okay. Okay, it's not for me, it's for a friend of mine.
Okay, hold on. Okay.
All right, thank you.
You're welcome. Hold on if you need help.
When I filed 751, me and my husband were separated, and my case is a transfer from Texas to VAWA Center. Then when I called them in...
One second. When you filed your I-751, you filed as a joint application, and then you requested a waiver based on abuse, being an abused spouse.
Yes, sir.
Okay, got it. All right. Continue.
And I called them, and they told me already my case is pending, and still I didn't get it, nothing. Didn't get it, the receipt number, nothing. Then I keep call them, and they told me I have to send a letter. I sent a letter.
Well, let me ask you a question. How do you know they even have your application? Well, you don't.
As I checked the money order, and I called them, then they told me
the money order was cashed.
Yes, sir.
Okay, so if the money order was cashed, they have your file, and then you just need to follow up with it. And
okay.
And so as long as the money order was cashed, somewhere is your application is being processed. So what I would do is on the money order, they would write your case number is on the money order. Get a copy of that money order if you don't have it. You will find your case number. Whoever took your application and cashed your money order wrote the case number. If it was sent to the Vermont Service Center, for example, it would start with EAC. If it was sent to Texas, it would start SRC, whatever it is. And so on the money order is your case number, and you follow up and say, hi, my name's Misa from Blue Rock, Arkansas. Here's a copy of my receipt. My cashed money order. On the cashed money order is my case number. I never heard anything. Can you please confirm, blah, 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 whatever you want to confirm. And they'll follow up with you.
Oh.
Okay?
All right.
All right?
Okay, thank you so
You're
much.
very welcome.
Thank you.
Okay.
So I filed for I-130 last November. It's been 7 months. I did my biometrics and everything, but didn't get anything.
You filed
after
an
that.
adjustment? You filed an adjustment?
Yes, I'm married to a U.S. citizen.
Okay. Did you file for a work permit?
I filed for all four I-130 and travel permit and work permit, yes.
Okay. And since you did your biometrics, did immigration write you back a letter saying you were missing documents or anything?
No, there was no missing document. And after biometric, after 5.5 months, I requested through my lawyer to do expedite, but they said, no,
you're not going to expedite anything. If it's 7 months, I don't know. I didn't do your case. I have no idea. I'm not the immigration service, but 7 months is too long to be waiting. So I'm not sure what happened. I'm happy to look at your documents to see what's going on, but generally after 6 months, you should have got everything. I don't have an answer why you didn't get it. I don't know. Usually people who don't get it within 6 months is because they screwed up their paperwork somehow. So perhaps your paperwork got screwed up and you don't know it, and everything got returned to your lawyer, and your lawyer just took care of it without telling you. It's a possibility, all right? Because 7 months, you should have gotten it already. I don't have an answer otherwise. My guess is that's the best guess I can make, but I don't know the answer. Okay, but if you want help, I can help you. Hold on 1 second, okay?
Brad, I have a question related to my wife's pending I-130 and my N-400. So I just want to give you a real quick immigration timeline. Actually, I got my
Tell me what your question is. I don't want to hear the timeline. Tell me your question, then I'll ask if I need to know the timeline.
Actually, I got a divorce in January 2019.
Right.
And I got I married again in April 2019, right. And I filed for my wife for I-130 in May 2019.
Okay, so you got your green card through wife number one. You divorced wife number one after you got your green card, and then married wife number two.
Yes.
Okay.
Yes.
Are you a resident or a citizen?
I'm a resident, and I already filed for N-400.
And how long have you had your green card when you filed for wife number two?
Less than 5 years.
Okay, so that case is going to be denied. So your initial I-130 that you filed for your second wife is going to be denied. And the reason is the law says that if you got your green card through marriage number one, you are barred from filing for spouse number two, even if you get a valid divorce, for 5 years from the time you get your green card unless you're a citizen.
Okay. But
so that first application you did is going to be worthless. Keep the marriage, it's fine, obviously. And either on the 5-year anniversary of you having a green card or on you becoming a citizen, you're going to file a new I-130 for your spouse. I would withdraw the first application.
Okay, so you mean I need to withdraw. So
Correct.
What if I upgrade my application once I become the citizen?
It's still going to be denied because it was filed as a resident within the first 5 years. You're going to have to file it again.
Oh, got you.
Right.
So I have to. So the only option is.
This is your option. Withdraw the application, and then you're going to refile a new I-130 either upon the 5-year anniversary of you having a green card or upon you becoming a citizen, whichever happens first. If it's on the 5-year anniversary of you having a green card and you're not a citizen yet, you're still going to file for it, and then when you become a citizen, then you'll upgrade that second application.
Okay, but the current one, sure must be denied, right?
Correct. 100% will be denied.
Okay.
All right.
Thanks.
You're very welcome.
Thanks a lot, Brad.
Okay.